I'm Jeff Clayton. I'm Executive Director of the American Bail Coalition. Thanks for taking the time to watch our series, 2021, an update on bail reform. In this part 2 of our series, we look at pretrial risk assessments, and we ask a simple question: is it time to move on? For years, bail reformers have posited that bail can be replaced with a pretrial risk assessment. And that was a new movement. Prior to that, risk assessment tools were just thought to be one more tool in the toolbox for judges to consider when setting bail and conditions of release. This movement put risk assessments in even a greater spotlight than they had previously been, and caused academics and other researchers to look at, are they effective? And do they cause issues of racial and other bias within the system? What is a risk assessment? It scores various factors to create a risk profile of the defendant. Eric Holder criticized risk assessments for using demographic factors, things like renting or owning a house, or having a cell phone or a home phone. But nonetheless, researchers determine some factors determine certain weights and scores, which arrives at a risk score for a defendant. Often, and nearly always, risk assessments group defendants into different risk scores or categories. And what I mean by that is we can call them low risk, medium risk, or high risk, or we can have them risk on a scale of 1 to 10, 1 being low risk, 10 being the highest risk. And then we put people into these categories of risk, and we discriminate against them for purposes of bail and conditions of release based on the grouping that we put them in. Many risk assessments will use what's called a praxis or a grid to assign increasingly harsh conditions of pretrial release to those who are in higher risk categories. And that's not evidence-based. There is no evidence that indicates that a higher risk defendant will respond to more conditions of release that will then obviate the risk. And that's important for policymakers to keep in mind. The cut points of the categories themselves are arbitrary. It's very important to realize this point. They are based on substantive judgments of how much failing to appear in court and new crimes while on bail we want to tolerate. For example, if we wanted to tolerate no crimes while on bail, we would consider everybody high risk. If we wanted to tolerate all crimes while on bail, we would consider everybody low risk. And so these cut points are not questions of science. They are questions of judgment. They are questions of tolerance that are not, we don't think, appropriately called scientific or that should be decided by judges. In other words, the categories are arbitrary, and thus the discrimination between defendant A and defendant B would be arbitrary. But what we really think policymakers need to do is educate themselves about the issues of risk assessments. And I would suggest that you immediately go to the website pretrialrisk.com, which was created by the Media Mobilizing Project. When first I reviewed this website, I thought, I wish I would have built this website because this is the most comprehensive website on the issues of pretrial risk assessments and tracking where around the country that risk assessments are being used and the problems that we're seeing. So again, start by educating yourself on the issues of pretrial risk assessments, and I think that will help you make better policy decisions. Let's talk a little bit about the research of pretrial risk assessments. Do they work? What issues have they had? I would direct you to a study by Professor Megan Stevenson of the University of Virginia School of Law. In a 2017 landmark article, she took a look at the Arnold Foundation tool, pulling data from the state of Kentucky, which was probably the richest data set that to date has been examined in terms of the success or failure of pretrial risk assessments. And what she essentially found is that the risk assessment process didn't work. In other words, it slightly increased failures to appear in court. It didn't decrease them. It slightly increased the new crimes while on bail. It didn't decrease them. And it had a meaningless impact on reducing the jail population. In other words, under the risk assessment regime, it was business as usual. The remainder of the article traces the lack of social science research, which the Arnold Foundation itself has recently pointed out, as the success of pretrial supervision and these risk assessments in creating any positive environment. To date, no other peer-reviewed study has been able to disprove this article, and I think it's an important read for that reason. Another recent study from Harvard University and the University of Massachusetts found that the Arnold Foundation risk assessment tool is gender biased. In other words, it treats female defendants as much lower risk than their male counterparts, all things equal, meaning that it unconstitutionally discriminates against male defendants in the provision of risk assessment, forcing male defendants to face higher bails and harsher conditions of pretrial release or potentially detention in states where preventative detention is allowed. And so that is a major issue of gender discrimination, and that study just came out in December 2020. ProPublica and many other studies have found racial bias in the Compass tool and other tools in the provision of these risk assessment services. And we think that the issue of racial bias the jury is out on it. It doesn't mean that every risk assessment tool is racially biased, but we have certainly seen some, and that should be a concern for policymakers. Are they making the situation worse? Regarding further concerns of discrimination, I think it's important to point to the Wisconsin Supreme Court decision in State versus Loomis. There, Mr. Loomis alleged that the Compass tool was gender biased. In other words, it treated male defendants much more harshly than their female counterpart. The Wisconsin Supreme Court, upon reviewing the matter, required due process warnings in order for the risk assessment to pass due process scrutiny. In other words, judges were to be warned that this was not a scientific process that took an individual defendant and, based on the individual defendant's characteristics, could accurately predict a risk of a new crime or risk of failing to appear in court. In other words, these tools are simply actuarial tools. We are grouping people. We are using group data to predict something that we really don't have a good basis to predict. And I think those due process warnings is something that all judges should be given in the United States, to understand that these are not scientific tools. They merely classify people into categories. They can't classify one individual within a category as opposed to another individual within a category as higher or lower risk. And that's an important distinction. One other key study, and I would read the ACLU of Colorado's study on the Colorado Pretrial Risk Assessment tool. The study there demonstrated that the tool was biased against minority defendants, but more importantly, was extremely biased against minority homeless defendants who were indigent. In other words, it treated people of different races differently and people of different races and socioeconomic backgrounds differently. The ACLU of Colorado called this a dangerous tool, a tool that should be eliminated within the state of Colorado. And so that's an important letter, and I would encourage you all to read it. It's important to point out that opposition to risk assessments is growing. The support for risk assessments is waning. In fact, groups that previously supported risk assessments are no longer supporting them. Groups that are calling for an end to pretrial risk assessments or greater transparency include groups like the Leadership Conference of Civil Rights, the Partnership on AI, the AI Now Institute, the NAACP and various local chapters around the country, the National ACLU and many local ACLUs around the country that have joined the fight against the use of risk assessment tools in the pretrial space. And of course, it's very important to point out that in California, Senate Bill 10 was posited as a replacement to the money bail system by creating California's no money bail system, a system of risk-based preventative detention using, you got it, pretrial risk assessments. California voters overwhelmingly rejected this system, and they did so primarily based on the use of a risk assessment algorithm. They did not want a risk assessment tool. They wanted their right to bail, and they didn't want judges' discretion clouded by the fact that some computer was telling a judge to believe something contrary to what the defendant would have wanted the judge to believe. And so in the end, Californians, they did not want computerized justice. They did not want risk assessment tools. They wanted their right to bail. It's very important to point out that the nation's oldest advocacy think tank on pretrial justice issues, the Pretrial Justice Institute, is now calling for an end to the use of pretrial risk assessments in the United States, largely due to issues of racial bias. How historic is this? It's very historic. It's very significant because the Pretrial Justice Institute candidly launched this movement 30 plus years ago to use these risk assessments. They cooperated with governments. They provided funding and research to embed risk assessments in every part of the process. And what they discovered after years and years of advocacy was that they made the system worse, that the system was not better, that the system did not decarcerate, that it wasn't fair, that if anything, when they embarked on their journey, it's less fair now than when they started. And what did they say in their report? They said risk assessment instruments simply add a veneer of scientific objectivity and mathematical precision to what are really very weak guesses about the future. Further, when risk assessment instruments do attempt to identify people who are more likely to commit a crime of violence, rates of rearrest for violence are quite low among even the high-risk group. This is a significant change and one that policymakers should take note of. There's been 27 prominent academics who have come together issuing letters to several Supreme Courts in opposition of risk assessments. This is an important development for several reasons. One, a lot of risk assessment research, like that calling the Arnold Foundation tool successful, is funded by the builders and people who have a financial interest in the success of risk assessment tools. There's various builders of these tools who issued a counter statement when the Pretrial Justice Institute came out with their statement. But many of those researchers are in the pocket of the Arnold Foundation and others who want to fund risk assessment research and demonstrate that it's success. Every one of these 27 prominent academics has no interest in the outcome of risk assessments. They took an independent look at risk assessments and they concluded that they were fatally flawed. As the statement details, the technical problems cannot be readily resolved. Indeed, they are much of problems of theory as they are of implementation. In other words, the risk assessment process is fatally flawed. They drafted letters to several Supreme Court justices demanding the end of the use of pretrial risk assessment tools. And yet, jurisdictions are continuing on, believing in the science of those people pushing risk assessment tools to say that they work. These 27 prominent academics have said it's time for jurisdictions instead to turn to other reforms. Obviously, what we've heard as the risk assessment science has broken down, and that not only can it not make bail decisions, that it can't really even inform decisions. And sometimes when it does it, it's biased and it makes the system worse. So what do we hear? We hear, well, the risk assessment doesn't set bail. Judges set bail. Judges can consider a risk assessment or not. Judges can deviate from the risk assessment. The judges can fix a risk assessment. But what research indicates is that when judicial discretion is applied to overrides of risk assessment, you guessed it, it makes the system worse. That the embedded bias only finds a new way to manifest its ugly head, and that is the deviation from a risk assessment, which evidence has shown that the decision will more than likely not favor minority defendants. The other important point to make is there's no scientific basis to override an instrument that was posited to be scientific that we are finding now not to be scientific. In other words, if we didn't believe it in the first place, then what basis would there be to scientifically override it? And so I think at the end of the day, if the risk assessment is not scientific, then it should just not be used. I don't think to say that, well, just throw it in the mix and let judges deal with it is a good answer to the question. And certainly not evidence-based, which is why we embarked on this road. Evidence-based practices, not evidence-based. So what I would encourage you to do is read the research. Go to our website, andbailcoalition.com. Go to our download center and read all of the research on opposition to risk assessment tools and effectiveness to risk assessment tools, in addition to all of the other research that we have. So let's summarize what we've learned here today. While we believe research demonstrates that some factors are predictive of behavior in the pretrial space, in other words, prior failures to appear in court may result in more failures to believe in court, we believe jurisdictions should abandon pretrial risk assessments. Scarce criminal resources in the criminal justice system should not be wasted on ineffective reforms, period. And sometimes these reforms may actually even worsen the system. We can't be in a position to waste precious resources on programs that simply don't work. The statutory factors or factors in the rule should be constantly reevaluated based on research demonstrating that particular factors or circumstances correlate with criminality or failure to appear in court. In other words, the legislature should study this and enact factors for judges to consider that make sense and that are supported by an adequate legislative record. Again, scarce criminal justice resources should not be devoted to programs like pretrial risk assessments that simply don't work. If you've got questions, go to our website, ambailcoalition.org, or if you'd like to contact me, shoot me an email at jclayton@americanbail.org. In summary, these pretrial risk assessments have significant problems. It'll be interesting to see how the debate goes and whether the policy will shift from a system of mass advocacy of risk assessments to an end to risk assessments within the United States of America. Thanks for taking the time to watch this module 2 of our series. We encourage you to watch the rest of our series, and thank you for your time. Good day.